A major piece of President Donald Trump's immigration crackdown has just been struck down in federal court. A judge in New York has ruled that the Trump administration could not automatically block immigrant visas for people from 75 countries simply because of their nationality, and the decision could force the government to reconsider visa applications that were previously refused under the policy. But there's an important detail getting lost in some of the headlines. This ruling does not eliminate all of Trump's travel restrictions. Here's what happened, why the judge ruled against the administration, and what this could mean for thousands of families trying to immigrate legally to the United States. On August 21, 2026, U.S. District Judge Jeannette Vargas of the Southern District of New York struck down a State Department policy that had effectively stopped the issuance of immigrant visas to nationals of 75 countries. The judge concluded that the policy was contrary to federal law and exceeded Secretary of State Marco Rubio's legal authority. The policy had been in effect since January 21, 2026. According to the State Department, the administration was reviewing immigration screening procedures because it believed people coming from certain countries presented a higher risk of relying on government benefits or becoming what immigration law calls a public charge. The list was enormous. It included countries across Africa, Asia, Europe, Latin America, the Caribbean, and the Middle East. Among them were Afghanistan, Bangladesh, Brazil, Colombia, Egypt, Ethiopia, Ghana, Guatemala, Iran, Iraq, Jamaica, Jordan, Lebanon, Morocco, Nepal, Nigeria, Pakistan, Russia, Somalia, Thailand, Uganda, and Yemen. The State Department's official list contained 75 countries in total. But this is where the legal dispute became especially important. Federal immigration law already allows consular officers to determine whether an immigrant is likely to become a public charge. That decision normally involves examining the individual applicant's circumstances, rather than automatically rejecting someone because of the passport they carry. Judge Vargas concluded that the State Department went much further than that. According to the court, the policy effectively required consular officers to refuse immigrant visas to people from those countries even when an officer's individual review suggested that the person was otherwise eligible and financially capable of supporting themselves. That distinction became central to the case. Congress has given consular officers authority to evaluate individual visa applicants under criteria established in immigration law. Vargas found that the blanket policy interfered with that system by making nationality itself the deciding factor for applicants covered by the directive. The judge also found that the policy conflicted with provisions of the Immigration and Nationality Act that restrict discrimination based on nationality in the issuance of immigrant visas. The case is known as Catholic Legal Immigration Network versus Rubio. It was brought by nonprofit organizations including the Catholic Legal Immigration Network and African Communities Together, along with individuals whose relatives or immigration cases were affected. Court records show the lawsuit was filed in February 2026 in the Southern District of New York. And the judge did more than simply criticize the policy. The court vacated it, meaning the policy itself was set aside. Visa refusals based solely on the 75-country directive were also set aside, meaning affected applications may have to be reconsidered under the regular immigration rules. For families caught in the system, that could be significant. Someone whose immigrant visa was refused solely because they were a national of one of these countries could potentially receive a new individualized assessment. However, this does not mean that every applicant will automatically receive a visa. Applicants still have to meet the normal requirements of U.S. immigration law. Consular officers can still determine that an individual is inadmissible for financial, criminal, security, health, or other legally recognized reasons. And the administration has not lost the ability to enforce the traditional public charge provision. In fact, the State Department currently has a separate procedure allowing certain immigrant visa applicants to provide additional financial evidence, and in some circumstances use a public charge bond, to overcome a public charge determination. There is also another major distinction viewers need to understand. This court ruling involved the 75-country immigrant visa policy that began January 21st. It is not the same thing as President Trump's broader national security travel restrictions. Under Presidential Proclamation 10998, which became effective January 1st, 2026, visa issuance and entry were fully or partially restricted for nationals of 39 countries, along with certain applicants using Palestinian Authority travel documents. Those restrictions were issued under a different policy and legal rationale. So headlines saying that Trump's entire travel ban has been overturned can be misleading. What Judge Vargas struck down was the 75-country blanket immigrant visa freeze tied to the public charge justification. That means somebody from a country affected by both policies could potentially receive relief from the 75-country freeze while still facing restrictions under the separate presidential proclamation. Politically, the decision represents another confrontation between the Trump administration and the federal courts over how much authority the executive branch has to reshape the immigration system without new legislation from Congress. The administration has argued that tougher screening is necessary to protect American taxpayers and ensure incoming immigrants can financially support themselves. The State Department said when announcing the policy that President Trump wanted immigrants to be financially self-sufficient rather than becoming a burden on Americans. Opponents, however, argued that the government could not replace individualized visa decisions with a sweeping nationality-based rule that Congress had not authorized. And Judge Vargas ultimately agreed with that legal argument. Now attention turns to implementation, and potentially an appeal. As this case moves forward, the biggest practical question will be how quickly previously affected immigrant visa applications are reconsidered and whether the Trump administration seeks further appellate relief. For families who spent months waiting while the freeze remained in place, the ruling could reopen a path that had effectively been closed. But it does not guarantee approval, and it does not erase every immigration restriction currently affecting the countries on the list. The bigger issue behind this case may ultimately be about presidential power itself. How far can an administration go in restricting legal immigration using executive authority before Congress, or the courts, draws the line? That debate is far from over. What do you think? Should the president have broader authority to suspend visas when the administration believes immigrants could become dependent on public assistance? Or should every applicant be evaluated individually under the immigration laws passed by Congress? Let me know your opinion in the comments. And if you want straightforward updates on immigration, politics, and major court decisions, subscribe to the channel and turn on notifications so you don't miss the next update.